Here's a case that came out today from the United States Court of Appeals for the 8th Circuit. Jenny Lee Stoner versus an insurance company. A woman lost her house in a flood. She had insurance, but the insurance company didn't want to pay. Chief Judge Riley said, "Despite our sympathy for Mrs. Jenny Stoner's loss, whose home of 50 years suffered significant damage from flooding of the White River in Phillips County, Arkansas, we must follow the law. Mrs. Stoner did not submit the one-page proof of loss form required by the federal standard flood insurance policy." Okay. When people seek benefits from a taxpayer-funded program, it is fair to require them to fill out the correct form. For the reasons set forth in McCartney, Mrs. Stoner's failure to complete and submit the proof of loss form precludes coverage as a matter of federal statutory, regulatory, and common law. What's that mean? It means that the insurance company doesn't have to pay her. Why? Because she didn't fill out a form. Here's what the form looks like. Proof of loss form. You just fill in the policy number. It takes less than 5 minutes. Fill out a couple of other things. You say when the flood happened. Write the amount of your insurance policy. A few more numbers. You sign it. You send it in. She didn't do it. It's supposed to take 0.08 hours. That's less than 5 minutes. Can they make an exception? We cannot make an exception. As Judge Richard S. Arnold said in his elegantly straightforward way, we judges cannot make law because we think a certain rule of law is a good thing. Very true. The legislature's in charge. The legislature even says that the insurance adjuster can help them fill out the form, but doesn't have to. Oh, Mrs. Stoner did not satisfy this condition precedent to coverage. In accordance with explicit federal law governing the National Flood Insurance Program, we reverse and remand for entry of judgment in favor of Farm Bureau. Oh, the insurance company gets to keep the money. They don't have to pay her. Oh, but they did give her one thing. Exercising our discretion under the Federal Rules of Appellate Procedure 39A, we declined to tax Farm Bureau's costs against Mrs. Stoner. The insurance company even had the audacity to ask the court to make Mrs. Stoner pay the costs of suing herself. Is this fair? Apparently so. The court said so. What do you think?